that the claimant continued in her employment until her resignation on 19 July 2018 by the letter of resignation dated 26 June 2018. That on 22nd October 2018, a period of over 3 months after the cessation of the employment relationship between the claimant and the first defendant, the claimant, through her solicitors, wrote a letter to the first defendant alleging unfair labor practices and demanding compensation for this alleged acts. It was contended by the defendants that the claimant is not entitled to any. It was contended by the defendant that the claimant is not entitled to any of her reliefs and urged the court to dismiss the claimant's action. Trial initially commenced before His Lordship Honorable Asian on 17th of September 2019. When upon His Lordship transfer, it started de novo before me on 29th November 2021. Testimony on oath sworn to on 15th of March 2019 and 17th of April 2019 and tendered exhibits CW1 to CW28. Claimant was thereafter cross-examined by learned counsel to the defendant. Claimant was thereafter cross-examined by learned counsel to the defendant on 16 March 2022, where exhibit CW28 was also tendered through CW1. The case of the claimant was then closed as there was no re-examination. Defendants often their case by calling is their witness, DW1, who adopted So sorry, I'm trying to get this thing. Sorry, my computer is misbehaving, but I'm about to overcome that, yes. Trial initially commenced before His Lordship Honorable Justice Asian on 17/9/2019, but upon His Lordship transfer, it started de novo before me on 29th November 2021, while the claimant testified as CW1 by adopting our witness testimony on oath sworn to on 15/3/2019 and 17/4/2019 and tender exhibit CW1 to CW28. Claimant was thereafter cross-examined by learned counsel to the defendant on 16 March 2022, where exhibit CW28 was also tendered through CW1. The case of the claimant was then closed as there was no re-examination. The defendant opened their case by calling defendants opened their case by calling their witness, Adebemi, who adopted his witness testimony on dated 3/4/2019 and tendered exhibit GTI1, GTI2, and GTI3. Following DW1's cross-examination and re-examination, the witness was discharged and the matter was adjourned for adoption of final written addresses. Defendant's final written addresses. Defendant's final written address dated 31st of January 2024 was filed on 16th February 2024, wherein 3 issues for determination were submitted by counsel to it. Number 1, where there was an employer-employee relationship between the claimant and the 2nd to 5th defendant. Number 2, where the claimant is entitled to remuneration from the 2nd to 5th defendant in the absence of any contract of employment between the claimant and the 2nd to 5th defendant. Number 3, where the claimant's performance of some regulatory compliance duties for the benefit of the 2nd to 5th defendant in line with express job description under the contract of employment between the claimant and the 4th defendant amounts to unfair labor practice. Counsel to the defendant submitted on issue 1 that there's no employer-employee relationship between the claimant and the 2nd to 5th defendant. Neither was there an offer or acceptance, nor was the claimant a public servant. The 2nd to 5th defendants are neither public offices or agencies of government. There's also no employment relationship between the claimant and the 2nd to 5th defendant under the common law, and there's no evidence of payment of wages whatsoever. That the basic requirement of contract, which include offer, acceptance, consideration, and intention to create legal relations, were lacking. Counsel refers to the case of UJAM and Institute of Management and Technology and others. Ghana Counsel also submitted that the claimant in paragraphs 19 to 22 of her witness statement on oath stated that she applied to the 1st defendant as an entity who offered her employment. However, the 2nd to 5th defendant never remunerated the claimant throughout her employment with the 1st defendant, since she was never employed by the 2nd to 5th defendant. Counsel further submitted that the instant case is not a multiple test and cannot be categorized into any of the factors listed by Supreme Court in the case of Siena Security Limited and Afro Park Limited. It's contention of counsel that apart from the fact established in paragraphs 4.1 of the defendant's final written address, there's no evidence before the court that the 2nd to 5th defendants ever instructed the claimant to carry out any function. Counsel further contended that the claimant wants the court to believe that the performance of certain specialized functions of the 2nd to 5th defendant at the behest of the 1st defendant was indicative of an employment contract. Counsel referred the court to the alleged human resources duties that the claimant carried out in line with the terms of her job description, which she wants the court to deduce a contract of employment. It's a submission of counsel that the human resources duties said to have been carried out by the claimant are rare and far between to be construed as indicative of an employment relationship in the capacity of human resource manager between the claimant and the 2nd to 5th defendant. That, as was seen in the Sheena's case and Shoprite Checkers Limited, frequency and series of action are required to infer contract by contract. Moreover, there are acts done in line with and within the job description under the contract of employment between the claimant and the 1st defendant. So it's the contention of counsel that aside from the above, the offer letters for the 2nd defendant were jointly signed by Mr. Boye Adebin, DW1. And the question to ask is whether a singular act of co-signing these letters make the said Mr. Adebemi an employee of the 2nd defendant. It is contended that based on the 1st defendant organizational policy, there are roles that require DW1 to provide certain functions according to sister companies, and the role of the company was one of such roles, which was communicated to her prior to assigning her job description, accepting to perform these functions, if ever or whenever she was called upon to perform them. Counsel stated that the claimant signed the offer letter for the 3rd defendant as group company secretary, indicating that the claimant knew she was not working for the 3rd defendant, but the 1st defendant. That is loosely referred to as the group. That the person referred to as the group managing director, who the claimant reported directly to the chief executive officer of the 1st defendant. that there is evidence before this court that the second defendant was not in existence at the time of the claimant's employment. That the question then is, how would a company not in existence enter into an employment contract with the claimant for the provision of services to the company during its non-existing years, when such services do not relate to the formation of the company? The claimant contended that she was employed by the second to the fifth defendant, but she did not furnish this court with an employment letter from any of the second to fifth defendants to back up her claim. It is a contention of counsel that the position of the company secretary is regulatory and not a matter of employment. A company secretary being an officer in a company is not or need not necessarily be an employee of that company. That's within the practice of corporate structure to have a company secretary serve more than one company. More so, related companies, a single individual or entity can serve as the company secretary of all the related companies, and this will not make such person or entity an employee of all the related companies. However, in all instances, what will guide the relationship is the agreement of the parties. Counsel submitted that there is evidence before the court that the claimant had a contract with the first defendant, which obligated her to serve in this position for the second to fifth defendant. Item 1 of Exhibit 26 was referred to. Furthermore, counsel submitted that the claimant never reported to the second to fifth defendant. All her reports were to the first defendant. That the claimant stated during course examination that she used to report to the GMD as a line manager. More so, the claimant addressed her resignation letter to the group MD, GTI Capital Limited, who is the chief executive officer of the first defendant. Counsel admitted that there is no contract between the claimant and the second to fifth defendant, that is of employment relationship. The claimant's contract of employment with the first defendant was the base for the claimant performing certain specialized duties for the second to fifth defendant. Counsel further submitted that having established that there was no employment relationship between the claimant and the second to fifth defendant, there is no uncontroverted evidence before the court that there was a written contract of employment between the claimant and the first defendant. On issue 2, the panel counsel submitted that the second to fifth defendant have no basis remunerating the claimant, as there's no employment history between them. However, whilst it is established that the claimant performs certain regulatory compliance duties to the benefit of the second to fourth defendant, the claimant was remunerated by the first defendant pursuant to the contract of employment between the claimant and the first defendant. That claimant admitted to being paid for her services. That claimant admitted to being paid for her services as stated in paragraph 2 of her deposition. It therefore follows that the claimant stating that she needs another form of remuneration will amount to double compensation, which is against the law. Counsel rely on the case of Bamameji and Otto. It is the first submission of a counsel that the claimant, having accepted payment for services she rendered for the defendant during the course of her employment of the first defendant without ever complaining, raises estoppel against the claimant. Counsel rely on section 169 of the Evidence Act. On issue 3, counsel submitted that the allegation of fraud and deceit by the claimant against the first defendant, which are criminal in nature, has not been proved by the claimant beyond reasonable doubt. In conclusion, it is the contention of counsel that the first defendant acted in good faith during the employment of the claimant, and as such, the claimant did not complain during her employment. The allegations raised in this suit show that it is an afterthought meant to fleece the defendant. Claimant's final written address is dated and filed on 4/3/2024, wherein counsel submitted 3 issues for retaliation to it, and I quote, whether the claimant worked for the second, third, fourth, and fifth defendant, and if the answer is yes, whether the claimant has been remunerated for the work done for the second, third, fourth, and fifth defendant. Number 2, whether DW1 can testify as witness on behalf of the second to fifth defendant. If the answer is no, whether the second to fifth defendant have called any evidence in this matter to challenge and controvert the claims of the claimant. Number 3, whether the defendants engaged and unfair labor practices in relation to the employment, engagement, and utilization of services of the claimant. On issue 1, counsel submitted that it is not in dispute that the claimant worked for the second to fifth defendant, that the claimant tendered evidence of work done for the defendant at various times within a period of about 19 months as human resources manager, head human capital development, company secretary, legal and admin services of the defendants. Counsel referred to the case of Minister of Agriculture and Natural Resources and Going Industry Limited. It's also a submission of a counsel that the claimant was employed by the first defendant, and during the course of the employment, the claimant was goaded to work for the second to fifth defendant without any form of remuneration. Counsel further submitted that when the W1 was asked during cross-examination whether the claimant was remunerated for the work done for the second to fifth defendant, he testified that she was paid by the first defendant, but failed to produce any evidence to that effect. Counsel further submitted that the burden of proof lies solely on the defendant to produce evidence of payment before the court to prove that the claimant was remunerated for the work done for the second to fifth defendant, and urged the court to hold so. Counsel referred the court to sections 131, 132, 136 of the Evidence Act, and the case of Xenon Pet and Gas Limited and MC Shipping Limited, Line Limited. Counsel contended that the claimant is not asking for double compensation, but to be compensated for the work done. That is strict law that parties are bound by the terms of their contract. Counsel also contended that a careful perusal of Exhibit CW 11 and 26 shows that the names of the second to fifth defendant were not mentioned, that the word company used by the claimant in Exhibit 26 is clear and cannot under any guise whatsoever be taken to include the second to fifth defendant, some of which were not in existence at the time of making Exhibit 26. Counsel admitted that it is strict law that the legally acceptable evidence by the recognition of the defendant as a group companies is a certificate of incorporation duly issued by the CAC. Counsel refers to the case of Chevron and Nupeng. To the contention of counsel that the argument of the defendant counsel and the evidence of DW1 is contrary to the provisions of CAMA and other extant laws. Therefore, the defendant cannot leverage on the misapplication of the word group or sisters to deny the due remuneration of the claimant. In addition, even the DW1 admitted that the defendant are not registered as a group of companies and therefore cannot operate legally as a group. Counsel urged the court to discountenance the submissions and testimony of the defendants on the issue of group of companies and sister companies. The DW1 testified under cross-examination that the companies are registered individually and each has its board and management. Counsel further urged the court to resist the temptation by the defendant to foist on the court the illegality of lumping the defendants together under any guise that is unknown to law in a manner that will enable the defendant to escape liability of remuneration of the claimant. Counsel maintained that it is notable that the second to fifth defendant are not privy to the contract of employment between the claimant and the first defendant, and they should not be used as a shield or scapegoat to escape liability from remunerating the claimant. It is also notable that there existed an employer contract of employment between the claimant and the second to fifth defendant in another breath in the individual capacities. In view of the foregoing, counsel also maintained that there are two distinct contracts of employment in this regard. There is one contract between the claimant and the first defendant, which is a written/express contract of employment, distinct from the implied contract of employment between the claimant and the second to fifth defendant. The defendant's counsel have argued in futility to misdirect this court by lumping both contracts as one, and also tried to impute and or make the second to fifth defendant privy to the contract of employment between the first defendant and the claimant, which by established evidence in this court, both contracts are distinct and separate contracts. The submission of counsel that the failure of the defendant to respond to the claimant's letters of demand is an admission of the claimant's claims. Counsel refers to the case of Cabo Air and Momberu Dechange. On issue 2, counsel contended that the second, third, fourth, and fifth defendant have not called any evidence or adduced any evidence in support of their case before the court, that it became apparent to the court that DW1 who testified on behalf of the second to fourth defendant, fifth defendant, is an incompetent witness who has no authority whatsoever to testify on behalf of the second to fifth defendant. Counsel submitted that it is straight that where a party refers to a document in his testimony as the bedrock of his authority to appear before the court and to testify for the second to fifth defendant, but that party has failed woefully to tender such document in evidence, the law will presume two things. Either the document does not exist or the document is being deliberately withheld because it is against the interest of the defendant. Counsel refers to Section 149 of the Evidence Act. The submission of counsel that testimony of DW1 is contradictory in fact and in law, as it is straight law that evidence and or admission elicited under cross-examination is binding on a party giving evidence, given the admission. Counsel refers to the case of Omishore and Arabia Shola. It is a contention of a counsel that the defendants were sued in their individual capacities as limited liability companies and were duly served. The judgment of defense cannot amount to credible evidence. It is tried that pleadings of parties cannot be treated as evidence before the court. The defendants, particularly the second to fifth defendant, fell in this regard. Counsel submitted on issue 3 that from the totality of the evidence before the court, it is clear that the defendant jointly and severally engaged in unfair labor practice, that unequivocal admission of the defendant in their pleadings and purported evidence, the court would observe that the defendants are deeply rooted on unfair labor practices. That this is what the claimant has come to highlight before the court for redress. Counsel submitted that it is instructive to point out at this stage that CW11 letter of employment was issued by the first defendant, and the second, third defendant are not parties to the exhibit, but in an attempt to justify the unfair labor practice of the defendant are seeking to rely on exhibit 11 and exhibit 26, which is the job description of the claimant in the employment of the first defendant. That a careful perusal of both exhibit CW11, CW12, and CW26 will show unequivocally that the names of the second to fifth defendant are not contained there. That every attempt by the defendant to justify the unfair labor practices of the defendant is incongruous and futile. It is repugnant to natural justice, equity, and good conscience, in all its ramifications. The submission of counsel that the claimant's case before the court is that, pursuant to exhibit CW11, the claimant was only employed by the first defendant, but was mandated to work for the second to fifth defendant without any form of remuneration whatsoever. It's a contention of a counsel that the act of all the defendants in this regard is contrary to the extant provisions of sections 45 and 46 of the Labor Act, Laws of Federation of Nigeria. Counsel argued that there's no law that mandates an employee to write a letter of complaint to his employer who has taken undue advantage of the employee to engage in unfair labor practices. That the claimant testified without any challenge that the use of the word GMD is a mere designation, does not have any legal basis, that is established and fully admitted by the defendant, that the defendant cannot legally operate as a group. Therefore, the argument of the defendant's GMD or group company secretary should be discountenanced in its entirety. Counsel finally urged the court to grant the claimant's reliefs. Defendants apply on points of law. I'll just skip that one. I have studied the pleadings filed and gone through the evidence presented by both parties. Having also considered the submissions of landed counsel for both parties, the issue I'll address is whether the claimant has proved her case to be entitled to the reliefs sought. It must be underscored that the claimant having sought for declaratory reliefs is charged with the burden of proving that she's entitled to the said reliefs, because the declaratory reliefs are not granted as a matter of course. The Supreme Court in this regard, here in the case of Jubrin, Bolaji, and Prince Rabiu, that, and I quote, it is settled that a claimant seeking declaratory reliefs must succeed on the strength of his own case, not on the weakness of the respondent's case. Therefore, the burden of proof on the claimant is quite heavy in the sense that such declaratory reliefs are not granted even on admission by the defendant, where he fails to establish his entitlement to the declaration by his evidence. See the case of Emenike and PDP. It is also the law that the determination of the employment rights to the employee who complains that his employment contract has been breached that has the burden to place before the court the terms and conditions of his employment that provide for his rights and obligations, and the manner such terms and conditions were breached. See the case of Bukar Modu Aji and Charles Basin Development Authority. It is tried too that whoever desires the court to give judgment as to legal rights or liability, depending on the existence of fact which he asserts, must prove those facts exist. See the case of C-Section 131 of the Evidence Act and the case of Calabar Cooperative Limited and ECO. The evidence given by the claimant is that she was employed by the first defendant as a company secretary, a legal advisor, and later her resumption in the employment of the first defendant. And after her resumption in the employment of the first defendant, she was intentionally mandated to act and work for the second to fifth defendant without any regard whatsoever to the extant rules and without remuneration and allowances, even though the first defendant does not deny that an employment relationship exists between it and the claimant. But it was contended on the other hand that the second to fifth defendant are strangers to the claimant's contract of employment. The defendants also contended that at all material times and to the knowledge of the claimant, each of the defendants, although a distinct and separate legal personality, a sister company, and they carry on business under a common corporate structure with offices located in the same building. From the evidence presented, Exhibit CW11 is the agreement employment contract between the claimant and the first defendant. The said exhibit, which is the bedrock of the employment relationship between the claimant and the first defendant, shows that it was the first defendant that employed the claimant. It also shows that the exhibit was signed by the representative of the first defendant alone. I also wish to observe that the claimant's resignation letter was addressed to the first defendant, but the names of the second to fifth defendants were not either mentioned in the letter of employment nor the letter of the resignation. It appears also that the second to third defendant were not in existence at when the claimant was employed. Generally, in law, only parties to a contract can enforce it. See the case of Coast Oil Limited and Tuboscope Vetco International Limited, UBA and Alhaji Babangida Jagaba. This brings me to a doctrine of privity of contract. Namely, a contract cannot confer enforceable rights or impose obligations arising under it on any person except parties to it, which is to protect the sanctity of contract. In other words, a non-party to a contract is not bound by it, even if it's made for its benefit. However, I'm not oblivious of the fact that the doctrine of privity of contract is not without its own limitations and exceptions. One common exception to its application is in the realm of agency relationship. See the case of registered trustee of Masters Vessel Ministries Limited and Incorporated. The question is whether there's any evidence of a triangular / co-employer relationship in this case on the primacy of fact, and also applying the control and integration test expounded by the Supreme Court in the case of Shena Security Limited and Afro Park Limited. The Labor Act in Section 91 defined contract of employment / worker and envisages a situation where there could be an oral contract of employment. In this case, no contract documents have been shown to have been issued to the claimant, nor anything evidencing the consultancy relation between the claimant and the second to fifth defendant. It will be hoped this court to determine if there are circumstances that can imply the existence of a contract of employment between the claimant and any or all of the dependents. Therefore, in determining the existence of an employment relationship, the fact of what was agreed and performed by the parties should be considered, and not only the name of the contract. This principle of measurement is known in law as the principle of primacy of fact, which has become enshrined in our law by its application. See the case of Oye Tayo and Daniel Bank PLC, and Union Beverages Limited and Pepsi Cola International Limited. Employment relationship comes in different forms. The International Labour Organization, ILO, terms an employment relationship that's meant to either mask the identity of the employer, where the person designated as an employer is an intermediary with the intention of releasing the real employer from any involvement in the employment relationship. and above all, from any responsibility to the workers, or mask the form in which the relationship is established, where the nature of the employment is intentionally misrepresented so as to deny certain rights and benefits to dependent workers as a disguised or objectively ambiguous employment relationship. See generally the ILO report titled The Scope of the Employment Relationship, ILO Office, Geneva 2093 at pages 24 to 25, and the case of Pengasan and Mobile Producing Nigeria Limited. It is tried that where a party inserts itself into the employment of other parties and acts in a controlling manner, then the court can and must infer triangular employment even where there's no letter of employment between it and the employee. Under the common law, parties to a simple contract of employment are the employer and the employee. That's a very literal and simple description of our employment relationship. The foregoing representing the orthodox view of the parties to a simple contract of employment. But today, because of the concept of outsourcing and casualization in the world of work, the law has now recognized the concept of co-employers of an employee and the concept of a triangular employment relationship. Our labor laws at the inception of the employment relationship and or during the pendency of the employment relationship admit that the character of the relationship may be altered as between the parties without the interposition of third parties. In appropriate cases, the courts have to consider the fact of co-employer status between two or more employees in relation to an employee. See the case of Onuma Lobby and MBC and Warri Refining. Onuma Lobby and MBC and Warri Refining and Petrochemical Company Limited. It should be noted at this point that from the pleadings and evidence before the court, parties are in agreement that the contractual relationship between the claimant and the first defendant is that of master and servant relationship. I've considered Exhibit 11, the employment letter issued to the claimant on the first defendant's letterhead, showing it to be between the claimant and GTI Capital Limited. Exhibit 11 is the job offer of the claimant by the first defendant. It states clearly that GTI Capital was pleased to offer the claimant employment, salary upgrade. Exhibit 12 was also issued by the first defendant. I'm of the view that the above exhibit communicated the claimant's employer to her, though belonging to the same group, and GTI Capital Limited was projected as the claimant's employer. I do not see that the second to fifth defendant are stated to be subsidiaries, affiliates, successors, or assigns of the first defendant. It is even immaterial if the second to fifth defendant are subsidiaries of the first defendant or not. What this court will keep its priorities on is the relationship between the parties before it. That's where it should draw its powers to grant the claimant's reliefs. There's no evidence before the court to show the triangular relationship the second to fifth defendant had with the first defendant on the one side and the claimant on the other side. There is also no evidence to establish that the first defendant is subject to the control of the second to fifth defendant. The claimant cannot claim that the second to fifth defendant are co-employers on the basis of appointment letter issued by the first defendant. I do not find from Exhibit CW11 to CW9 or any other exhibit at all proof of the co-employee status of the second to fifth defendant. It's clear without doubt that even though the current law standard and international best practices recognize the reality and existence of triangular/co-employment relationship, such cannot be said to be the case in the peculiar instances of this case. It is in the light of this that I find that there's no triangular/co-employment relationship status among the second to fifth defendant in this case. In view of all the above, I'm of the opinion that there's no existing control relationship between the claimant and the fifth defendant. Claimant's relief A is for a declaration that the co-employment or triangular relationship employment of the second to fifth defendant under the misrepresentation of being employed by the first defendant without commensurate remuneration amounts to unfair labor practice. Having earlier held that there's no existing contractual relationship between the claimant and the second to fifth defendant, this relief also fails. Relief B is for a declaration that the manner given to the claimant by the first defendant to work for the second to fifth defendant is contrary to the terms of employment of the claimant as contained in the letter of employment. The defendant contended that upon the claimant's resumption and after a detailed briefing with the management of the defendant, the claimant documented a detailed job description dated 5th December 2016, duly signed by the claimant, and that the claimant without any objection carried out those roles and responsibilities in line with a detailed job description. I've carefully considered the condition of both parties with regards to Exhibit CW26, which explicitly outlines the job description of the claimant. Moreover, the last paragraph of Exhibit CW26 reads thus, and I quote, all necessary and incidental duties will be carried out effectively as may be assigned by either the board or management. I am by this in agreement with the assertion of the defendant that the claimant has a duty by virtue of our job description to perform those duties. Reliefs A to F fail and are accordingly dismissed. Relief H, G, H, and I are generally for general damages for unfair labor practices perpetrated against the claimant, for breach of contract, and for discrimination, gender insensitivity, intimidation, and untold hardship meted out to the claimant are accordingly declined as a result of the failure of the substantive reliefs A to F. All said claimant's suit accordingly fails in its entirety and is hereby dismissed.
As the court pleases.
Yes.
My lord. My lord. On behalf of the defendant, we want to profusely express our gratitude to court for the industry and the resourcefulness displayed in the judgment just delivered by my lord, by my noble lord.
Thank you.
My lord, we all have become wiser by the erudite judgment delivered by my lord. My lord, in the circumstance, my lord, because cause follows events, sir. We'll be asking for cause, my lord. My lord, cause follows events. Will be brought to court since 2019, my lord. It's a case that has lasted 6 years. All parties have been put to enormous cost. We do know, we concede. But my lord, we're asking for cost. It's only fair to ask for cost. And my lord, we're asking for a cost of 1 million naira against the defendant, sir. Against the claimant in favor of the defendant, sir. In favor of the second, particularly the second, third, fourth, and fifth defendant, sir.
In favor of who?
My lord, if I may. My lord.
Sir, Mr. Samuel, just hold on. So just a minute, please. Just a minute. Mr. Samuel, are you considering to the cost?
My lord, my principal, Mr. Samuel Azubolu, is currently on transit, my lord. And I crave the indulgence of the court to speak on his behalf.
Okay, is that Mr.
Bariko? Bariko.
Okay. Bariko, okay.
Who appeared with Mr. Shibu Sikolu. My lord, we are grateful for the judgment just read. Much obliged, my lord. As to the cost, my lord,
yes,
we do not concede the cost. Actually, if the defendant is pleading for court. Let him appeal. My lord, the court at this time is functions official. The court has read its judgment, and the court did not award costs in its judgment. My lord, we pray that let parties bear their respective costs. It is our humble
Okay.
submission, my lord.
So sorry, course is declined.
As the court pleases.
It's declined. It's declined, yes.
As the court pleases.
Yes.
As the court pleases. As the court pleases, my lord.
Yes.
My lord, sir, I took hint from the last, the one that was called before us now that all applications for CTC can be addressed to Lagos. But I want to make a special inquiry from my lord, sir. Some of us, I particularly have an application I intend to submit to your lordship for reference. I my lord will understand the kind.
Oh, no.
Yes,
That one
that can be
you
sent
can.
to my lord.
You can send it to your.
To you, okay.
Or you can what you do, ba?
Yes,
Mr.
my lord.
Mr. Adele.
Adele, sir. Yes, my lord.
When the application is prepared, bah?
Yes, my lord. Yes, my lord.
You can. You have two options. You can go and meet Hajia.
Ask her, please. Yes, my lord.
Give it to Hajia.
Yes, my lord.
Hajia will just scan it and send the soft copy to me.
I'm grateful, my lord. I'm grateful, my lord.
Yeah, then we can. Then we can work on the on the soft copy.
As copies. I'm grateful, my lord. I'm very grateful, my lord. Yes. Thank you, my lord. We are indeed very grateful.
It's okay. Thank you so much.
Yes, my lord.
Thank you. Thank you, Mr. Bariko. It's okay. Thank you.
Do I have the leave of my love to exit, sir?
You can leave. Thank you. Good afternoon. You can leave.
Yes.
Thank you.
I'm grateful, my lord. Your
Yes,
kind
Mr. Bariko.
to leave.
Thank you, Mr. Bariko. You can leave. Thank you.
Thank you, my lord.
Thank you.
Thank you, my lord.
And
how do I leave now? I want to leave.
yes, Stephanie.
Yes, my lord. Good afternoon.
Okay, you're around.
Yes, my lord.
What about the counsel for the defendant?
My lord, I'm around.
Before I deliver this your judgment, I want to be clear about some few things, please.
Okay, my lord.
Can you hear me?
Yes, my lord.
Is Emmanuel ba? Emmanuel.
Yes, my lord. Jeffrey, spelled as Geoffrey.
Can you also hear me? Can you hear me?
Yes, my
Okay,
lord. I can hear you clearly.
But can you see me? I'm trying to. It's showing me something. It's saying.
My lord, we can see your hand, my lord.
You can still see me. I'm trying to remove something. It's okay.
Yes, you can see it clearly, my lord.
Okay, let me. I don't know whether let me just record you so that we continue with the talk. So parties absent.
Yes, my lord. On my part,
my lord, the Clement is present.
Okay, Clement is present.
Yes, my lord. Emeka Oba.
Okay, Clement is present.
Yes, my lord. The Clement is present.
Is Simon about something, Simon?
Yes.
Okay. Ume something ba?
Yes, Simeon Ume. Simeon Ume.
Is this Simeon? Okay, yes. Simeon I Umeba.
Yes, my lord.
Is in court.
I'm not.
Yes, my lord.
I'm not seeing his name here.
The Emeka Oba, that's me.
Emeka? Is it Emeka? Do you have any person Emeka?
His name is Simon Ume, my lord.
Eh?
My lord,
He's in court,
name is Simon Ume. Yes, he's in court.
Okay, Stephanie. Stephanie Okwanga. Is it double N, Stephanie? Is what?
Yes,
double N?
Yes, ma'am.
Okwanga.
Okwanga is UKONGA.
Ojoy.
Ojekere, my lord.
For the claimant.
For the claimant.
Yes, Mr. Emmanuel.
Jeffrey.
Emmanuel.
Jeffrey. Geoffrey.
Okay, for the defendant.
The defendant, my lord.
Hello, my lord. Good afternoon,
Yes,
sir.
Mr. Yes.
Sir, please, sir. My name is Simon. Ifeanyi Chukwume.
Okay, you are the claimant?
Yes, sir. Simon. Simon. Simon Ifeanyi Chukwume. I'm not Stephen.
I said you are the claimant.
I'm the claimant, sir.
Okay, that I stands for Ifeanyi.
Ifeanyi Chukwu, yes, sir.
Okay, then Ume.
Ume.
Ume, okay. Okay, it's okay. So, Mr. Emmanuel. Mr. Emmanuel.
Yes, my lord.
Can you hear me?
Yes, my lord. I'm responding. I can hear you. Can you hear me,
Hey,
my lord?
please, even though the matter is supposed to be for judgment, but I want to be clear about some things, please.
Okay.
Yes. I don't know whether you can address me on that, or I should allow you to file something, or you can, if you can be able to do it, orally.
Okay, let me hear what it is so that.
Mr. Emmanuel.
Yes, my lord.
When you look at page 29 of the Human Resources Policies and Procedures Manual,
yes, my lord.
This is it chapter or section on sick leave 5.3. Is it chapter or paragraph or what?
I don't have it here, my lord.
Okay, yes. I'm just trying to to put you through.
Okay.
It's generally on sick leave.
Okay, yes, my lord.
Yes, it's contained on page 29, 28 to 29.
Okay. Yes.
It's chapter 5.3. So on that chapter 5. If you can write it, please. 5.3.2.2.
Okay.
Yes. 5.3.2.2. All of you address that issue.
Okay.
Let me read to you what the part of the chapter has said. It says a member of staff may be required to Can you hear me?
Yes, my lord, clearly.
It said a member of staff may be required to provide certification to the bank if he or she takes a single day of sick leave on a Monday or Friday immediately before or after a public holiday, or if the bank considers he or she is going to a certain she's doing so to a pattern and on a regular or frequent basis. Then it says sick leave certificates from health centers, teaching and general hospitals, and other medical institutions will be accepted only when it says the staff member is actually receiving treatment from such hospitals as inpatients, that is on admission.
Yes, my lord.
And the next one says when he or she has been referred to such hospital or centers by the bank's doctors or the standby hospitals. So it's saying that when somebody is submitting any medical certificate on ground of his absence, it has to be a medical certificate showing that he's an inpatient, that he's on admission.
Yes, my lord.
And it has to be from medical centers, teaching hospitals, or referred by the banks that the defendant's doctors.
Yes, my lord, and I can
then
explain. Okay, go ahead, my lord.
Then it says such certificates must be produced within 24 hours of the admission of the staff into the health establishment while the staff is being treated in a location without a bank doctor. The certificate must be produced within 3 days of hospitalization. and thereafter weekly for the duration of the sickness. The staff is responsible for drawing the attention of the hospital to this requirement. Then it says salary may not be paid for the absence from duty on the ground of ill health, not covered by the procedure laid down above. And the bank may also not be responsible for the medical expenses incurred. So my question to you, Mr. Emmanuel, is that if somebody is sick, he's expected to produce medical certificates from the recognized institutions, referred by the bank's doctors. But this one is saying that his failure to, this one is saying that in the case where a staff falls sick, okay, salary may not be paid for absence from duty on the ground of ill health, not covered by the procedure laid down above. And the bank may also not be responsible. So does that mean that when somebody fails to meet the above requirement of producing medical certificate by the recognized institutions referred to by the defendant's doctors, so it means the only punishment is the non-payment of the salary, not dismissal.
Okay, yes, my lord,
yes.
I understand my lord's question.
Yes, because Mr. Emmanuel.
Yes, my lord.
From the pleadings, it's agreed that this person has been sick. Even from the report from some of the armament in the defendant's pleadings, they're even saying that there was some that even one of the doctors said that he was not going to give him a certificate of fitness. So from this, what I want to ask is that when somebody is absent on the ground of ill health and is not able to meet the requirements in this chapter 5.3.2.2, does it mean that the punishment is just non-payment of salaries for the period he was absent?
Well, no, my lord. Okay, I see the point my lord is making, and I understand it clearly.
Yes.
Okay.
Yes.
This particular case, he was absent for 211 days or thereabouts. So that is the fact.
220, I think 23 days. 2 to 3 days.
2 to 3 days. So it's not as though he was absent for just few days and his salary was withheld. So it's not that is the penalty. It's not that though somebody can be away, not comply with this procedure for let's say 10 years and come back to say I am not feeling fine. It's just not correct. And the one of the ways, the rationale behind this procedure and why it's a bit stringent is to just ensure that people do not abandon work. Yes. People do not just leave work and then go to their friends, their friend is a medical doctor, and get a
medical certificate.
And that's why those measures are put in place.
Yes, so, I understand.
So the penalty is not just, and it's not just because he's not feeling fine and he didn't show up at work, but there are other circumstances that made them to say, no, you've been away from work for over 211 days. There is no, and you don't have permission to do that.
Yes.
So it amounts to
because the reason why I'm asking this is that, Mr. Emmanuel, the claimants raised this in their address. They raised it in their address that the punishment for for not for somebody being absent on the ground of ill health is non-payment of salary, not dismissal.
No, but I remember that we also addressed it in our reply.
Yes, because I know, but I wasn't, because let me even read to you what you said in your reply. Because I'm not clear about your reply. That's why I'm asking, because I don't want to go and misunderstand you.
Okay, my lord.
Yeah, but let me read to you what you said in the reply. Firstly, this is the contention of the claimant, that the absence from work without medical cover pursuant to paragraphs 5.3.2.3 of the manual is non-payment of salary for the period of ill health not covered by sick certificate. Then in your reply, you said, it is the argument of counsel that the submission of the defendant that, okay, this is also part of the argument of the claimant. It is the argument of counsel that submission of the defendant that the claimant did not have a letter of approval or medical certificate for his absence from work for 2 to 3 working days. It's not supported by evidence as exhibits.
My lord, you are currently muted.
So it's saying that then you said it's a submission of counsel that apart from the initial sick leave certificate covering 2 weeks, none of the medical reports presented by the claimant can justify the claimant's absence from work for 2 to 3 working days for a number of reasons. Firstly, only the medical certificate issued by the bank's hospital is valid. Number 2, certificate issued by other hospitals are valid if they meet 2 conditions to it. The staff member is receiving treatment as an inpatient, and the staff is referred to the hospital by the defendant's doctors or by the standby hospitals. Then that neither of these conditions is met in the instance case, that the claimant was neither an inpatient nor was he referred to the hospital or to the Harbour-born hospital setter by the defendant hospital. The second reason is that that his absence is unjustified is that certificate has to be produced weekly for the duration of the sickness. Counsel referred to section 5.3.2.2 of the manual that it is clear from the available evidence before the court that this was not done. Counsel admitted that having established that aside from the initial 2 weeks, the claimant presented no medical certificate to cover the entire period of his absence, it is clear that the claimant was absent from work for a period of 30 days without permission sought and obtained, and as such was liable under section. What I'm trying to say is that under section or chapter 5.3.2.2 is saying if the claimant doesn't meet the requirements there, the penalty or the, aftermath is non-payment of salary. Isn't it? Because in this case, Mr. Emmanuel, it's agreed that the claimant was sick or has been sick.
Yes, my lord.
Yes, what the defendant is contending is that he didn't produce medical certificate as an inpatient, isn't it? And
Yes,
that medical certificate has to be weekly, and it also has to be from a hospital recognized by the defendant doctors. So so it means if that fails, the only penalty is non-payment of salary.
Okay.
It's established and agreed that this person has been sick.
Okay, my lord, I see
Yes,
what.
Can this person be held, to have absconded or absented from work after all the parties have agreed and acknowledge the fact that yes, this person has been sick?
Yeah, so my lord, yes. This case is very peculiar. So the peculiar facts of the case
how peculiar? Yes.
Plays an important lesson. Now, firstly, it's not just that the claimant failed to produce certificates. He couldn't have even produced it because he's not an inpatient. People,
yes,
it's not every kind of sickness that would require sick leave.
Yes.
The kind of sickness that would entitle somebody to sick leave
yes,
is one that, okay, the person is not able to move about.
Yes, I agree. That's
one.
Yes.
Secondly, the claimant is not in that category. So if this initial part that says you are not entitled to salary is when you've even complied, you are entitled to the medical certificate, but out of your own willful or out of your own negligence or so, you failed to get produce the medical certificate, then we can say you are not entitled to this. But we know that just because of procedure, and it is clear to everybody that you were ill and you were admitted. Another reason why that is not so in the case of the claimant. He was not admitted at all.